have to sit as a judge. So when I get an agreed upon set of instructions, as much as it pains me, knowing that they're incorrect, I have to read them. Page 4. Page 4 is A18-781255, Harris versus Del Casal.
Morning, Your Honor.
Morning, counsel.
Kurt Harris, on behalf of plaintiffs.
Morning, Judge. Alda Anderson here.
Good morning, Ms. Anderson. I saw Ms.
And good-
Blankus, you there? Sorry, Mr. Needham. I'm sorry.
Thank you. Good morning, Your Honor. This is Attorney Alda Anderson for Defendant Del Casal.
All right. I've got plaintiff's motion to reconsider. First of all, here's where I got some issues with it. Is it my understanding that I signed an order with the understanding that all parties had reviewed it, and that wasn't the case? That I signed an order that was authored, I believe, by you, Mr. Needham, but I'm being told that, Mr. Harris, you didn't review it or didn't have the opportunity to review it? Is that the case?
I don't believe that's the case, Your Honor.
All right, well then why was that what I was being led to believe here was that plaintiff is claiming defendant counsel did not run the current order regarding by counsel prior to having it submitted to the court. Isn't that what was alleged in the pleadings that I received?
I did not sign off on the order.
Did you have a chance to review it?
I don't believe I did review it.
Did you have a chance to review it, Mr.
I
Harris?
may have.
Okay,
Judge,
so you had a chance. So
yeah.
It wasn't that, because I was going to give Mr. Needham a tongue lashing that he didn't follow what I think all attorneys know is the unwritten protocol rule that we always pass orders by the other side before we submit them to a judge. Because once they get submitted to the judge believes, unless someone sends a competing order, that all parties agree to the language.
Your Honor issued the minutes, and it was consistent with the minutes.
Okay, so
And
I had
that
a
really
valid
was
order.
Really not the thrust of the motion.
Okay. Your motion is basically, Judge, you messed up, and here's why.
Well, not so much, Judge, you messed up.
There's no new law.
No, new evidence.
Okay, new evidence.
Solely new evidence was that the only thing I wanted, Your Honor, just wanted to make a record that I had submitted that particular instruction about clear and convincing proof to both counsels on 3 separate occasions, and they objected to those. And then, as Your Honor stated at the prior hearing, they came in, they said they agreed to the jury instructions as they were constituted at that time. I just wanted to make a record, Your Honor, that they objected to the clear and convincing proof instructions, and it was provided to them 3 occasions, and I just put those as exhibits on the motion. And that's the sole
But
basis.
when we agreed to, by all the parties, these are the instructions that all the parties agreed to. Are there any proposed jury instructions by the plaintiff that were not given? Did I hear at that time, Your Honor? I proposed a clear and convincing evidence standard because I'm seeking punitive damages. That was proposed to you, Your Honor, but it's not being given. Was that ever done?
You did not hear that, Judge.
Okay, so
No, that was not done.
then it was waived. Okay, and then what happened was, because again, unfortunately, I am not allowed to practice law. I have to sit as a judge. So when I get an agreed upon set of instructions, as much as it pains me, knowing that they're incorrect, I have to read them. And in this case, this jury was not given a jury instruction on the basis for clear and convincing evidence so that they could find punitive damages, correct? Therefore, the punitive damage claim is out. It's an invalid jury decision based upon the fact that the attorneys did not present a jury instruction for clear and convincing evidence. That's the end of the discussion. Motion to reconsider is denied.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Your Honor.